Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in North Dakota and outline some simple steps that landlords can take to initiate an eviction. In this video, we'll talk about what the eviction process looks like, how North Dakota law handles evictions, and how to legally remove a non-compliant tenant from a property. Watch till the end of this video to find a fillable eviction notice that meets North Dakota requirements and that you can customize for your property. First, what is an eviction? Eviction is the process of legally removing a tenant. Without the involvement of a court, landlords cannot change locks on a property or physically remove a tenant from that property. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. One thing to note is that an eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. In North Dakota, if a tenant breaches the terms of their lease contract, the landlord can issue what's called a notice to quit. In other states, there are many iterations of this form for the landlord to choose from, depending on the circumstance, but in North Dakota, there are just two versions. The form known as the 3-day notice of intention to evict lets the tenant know that there's a problem, and if the problem doesn't get fixed within 3 days, an eviction lawsuit will be filed. A problem can include a failure to pay rent or another violation of the lease, such as disturbing the neighbor's peace. Basically, the notice gives the tenant 3 days to pay up or resolve a matter if they want to avoid going to court. There's also a form called a 30-day notice to quit. This one gets used by either the landlord or the tenant to terminate a month-to-month tenancy as a matter of routine, when there is no violation of the lease agreement. When tenants are ending a month-to-month lease, they need to only provide 28 days notice, whereas the landlord needs to provide a full 30. The notice of intention to evict or the notice to quit must be served on the tenant. There are two ways to arrange for the service of notice. One, it can be given to the sheriff, who will, for a fee, properly serve the documents and provide proof of service. The second way is to get someone who's at least 18 years old and does not have a stake in the eviction action to serve the notice. The person must also provide proof of service by filling out an affidavit of service by personal delivery. At least one attempt must be made to serve the notice between the hours of 6 p.m. and 10 p.m. If the tenant is not found, the sheriff can post the notice conspicuously on the premises. If the tenant doesn't comply with the notice, the landlord can file an eviction suit in the local district court where the property is located. The first two forms are known as a complaint and a summons. The complaint explains the reason for the eviction, and the summons notifies the tenant of the date and time of the scheduled eviction hearing. Copies should be made of both forms. The summons should be signed in front of the clerk at the district court. The landlord should also file a copy of the lease agreement, a copy of the notice of intention to evict, and proof that the notice was served on the tenant. The fee to file all of the relevant paperwork is $80. Once the forms have been filed, the clerk will schedule a hearing date. The date may not be fewer than 3 nor more than 15 days from the date the summons is issued. Copies of the complaint and summons forms must be served on the tenant. These can be served in person by the sheriff or another person who does not have stake in the eviction action. If the tenant can't be found, then the sheriff may post the forms on the rental property. Both parties should attend the hearing, which is presided over by a judge or judicial referee. The landlord and tenant will each have an opportunity to tell their side of the story, and the judge or judicial referee will either grant or dismiss the eviction. The landlord can ask for a money judgment to recover outstanding rent, fees associated with the service of court documents, and attorney's fees. If the court grants the eviction, the landlord might be asked to file an affidavit of identification with the court. The affidavit must be signed in the presence of a notary public and will seal the eviction. There are some specific legal rules to evictions in North Dakota, but we've got everything you need to get the process started. From eviction notices to court documents, you can access all of them at the link below. And don't forget to subscribe to find more videos on legal topics in business, real estate, and more.